In Vertical Aerospace Group Limited versus Thandiwe Ngoma, Tom Little KC, sitting as a deputy judge of the High Court, determined the appropriate costs order following a contested return date at which several interlinking applications had been argued. These included the defendant's application to set aside an imaging order on grounds of failure of full and frank disclosure, and the claimant's application for an interrogation order in relation to the defendant's electronic devices. The claimant contended it had succeeded overall and sought its costs, including the costs of the supervising solicitor and IT expert engaged in connection with the imaging order. The defendant sought her costs of resisting the refused interrogation order application and argued any remaining costs should be costs in the case or costs reserved. Applying Rule 44.2, the court found no clear overall winner. The defendant's set-aside application failed, but the affidavit terms were varied appreciably in her favour. The interrogation order was refused, yet the court declined the defendant's preferred approach to disclosure, producing a middle ground outcome. The court considered an issue-based order under Rule 44.2, subsection 6, paragraph F, but rejected it, as the issues were too interwoven to separate without artificiality. A percentage-based order was similarly declined. Expressly considering but rejecting costs reserved, the court ordered costs in the case, finding that approximately 50% of hearing time had produced a positive outcome for each party. Quote, "All of the applications and arguments were interlinking, and therefore it would not be appropriate to make individual costs orders on individual applications. The reality is that roughly 50% of time was spent on arguments which led to a positive outcome in some way for each side. Properly applying Rule 44.2 to the circumstances before me, the appropriate costs order to make is costs in the case. I make clear that I considered whether the costs should be reserved or whether some part of the cost should be reserved. However, given what was contested in this case, I do not regard that order as the correct one to make here."
For a detailed summary of this decision, visit tmclegal.co.uk.